Welcome back. We are busy with retirement funds, class 4, and we are now starting with Unit 2, Introduction to Retirement Funds. Right, whilst retirement planning is a significant and holistic subject, the material covered is as follows. Retirement wealth preservation. Now, preservation means that you preserve what you have saved. Establish a wealth preservation strategy is crucial to any complete financial portfolio. You need a method or a way to then preserve the money that you've saved up so that you can then use it at a later stage. You have worked hard to achieve your success and you want to be sure that your investments are available to you when the time comes to enjoy them and that when that time arrives. We can help you develop a long-term plan to preserve what you have already earned and help you then to grow it. This part consists of an introduction to retirement planning for an individual, the types of retirement vehicles available to invest for retirement, the calculation of retirement needs, and then the tax treatment of the retirement fund contributions and benefits. All right, let's look at the term pension fund benefits. As of the 1st of March 2019, South Africans who are members of a pension or provident fund will hopefully start to feel the impact of three new regulations on their retirement savings. The so-called default regulations came into effect on March 1st and affect three crucial areas of retirement savings. Number one is how your contributions are invested while accumulating savings. That's Regulation 37 of the Pension Fund Act. Number two, it is easy to leave your savings invested when you change jobs. That's taken up in Regulation 38. And thirdly, and the options you have available to convert your retirement savings into a monthly pension for life when you retire, and that is taken up in Regulation 39. Right, just to define retirement funds, retirement funds are established to provide those covered by the fund with an income to replace earnings in the event of their retirement or perhaps the early retirement through ill health. Such funds will often additionally provide benefits for surviving dependents in the event of death or disability of the member. Retirement funds in South Africa are managed in terms of the Pension Fund Act 1956. The Act defines pensions as follows. A. Any association of persons established with the object of providing annuities or lump sum payments for members or former members of such association upon the reaching their retirement dates or for the dependents of such members or former members upon the death of such members or former members, or B. Any business carried on under a scheme or arrangement established with the object of providing annuities or lump sum payments for persons who belong to or belong to the class of persons whose benefit that scheme or arrangement has been established when they reach their retirement dates, or for dependents of such persons upon the death of those persons, or C. Any association of persons or business carried on under a scheme or arrangement established with the object of receiving, administering, investing, and paying benefits that became payable in terms of the employment of a member on behalf of a beneficiary or beneficiaries payable on the death of more than one member or one or more pension funds. Right, the registration of pension funds. Section 4 of the Pension Fund Act of 1956 provides for the registration of pension funds. Number one, every pension fund must, before commencing any pension fund business, A. Apply to the registrar for registration under the Act. You can't just operate a pension fund without being registered. B. Be provisionally or finally registered. Again, you need to have registration before you can start with a pension fund. Applications too are processed and granted by the registrar once all requirements have been met for the registration of the fund and the prescribed fee has been paid. Right, upon successful registration, the registrar will provide the following: a registration certificate, details of the fund as entered into by the fund's register, endorsed, approved rules of the fund. The Act provides for the provisional registration for a period of up to 5 years. Every retirement fund becomes a juristic person, a body corporate, on the receipt by its principal officer of written confirmation of its registration by the registrar, meaning it becomes capable of suing and being sued in the name of doing all the lawful things to exercise the powers vested into it, to carry out the functions ascribed to it in terms of its rules, and to carry out its duties in terms of the Act. Cancellation or suspension of registration of retirement funds. Section 27 of the Act provides for the cancellation or the suspension of registration of funds under the following circumstances. 1. The registrar shall cancel the registration of a fund, A, on proof of his satisfaction that the fund has ceased to exist, or B, if the registrar and the fund agreed that the fund was registered by mistake in circumstances not amounting to fraud, then the registrar may suspend the fund whilst allowing the fund to rectify any mistakes. If not rectified, the registrar will proceed to cancel the registration. Secondly, the registrar may apply to the court for the cancellation or the suspension of registration of a fund if the fund has willfully and after notice from the registrar violated any provisions of the Act. 3. The court may cancel the fund's registration or suspend such registration for such period of as it thinks fit, and may attach to such cancellation or suspension such conditions as it thinks desirable, or make any other order which in circumstances it thinks desirable. Fourthly, unless the court otherwise orders, the cost of suspension or cancellation are paid by the fund and shall be the first charge upon the assets of such a fund. Right, then let's look at the rules of a retirement fund. Section 11 and Section 12 of the Act prescribe that number 1, the business of a retirement fund shall be governed by a set of rules which shall comply with the prescribed requirements in terms of the regulations. 2. No rule shall be of any force unless those rules have been approved and endorsed by the registrar. 3. Subject to the provisions of this Act, the rules of a retirement fund shall be binding on the fund and its members, employer and officers, and any person who has a claim on the fund. And fourthly, every member of a retirement fund shall be entitled to request to inspect a copy of the rules of the fund. That's set out in Section 35 of the Act. And 5, notwithstanding the provisions above, if the retirement fund rules conflict with the Act or on any aspect, then the provisions of the Act shall apply. Right, can you make amendments to the rules? Yes. Number 1, a retirement fund may alter or rescind or make any addition to its rules, provided that such alterations, rescission, or additions shall affect the rights of any creditors of the fund other than as a member or a shareholder. Secondly, all proposed amendments shall be submitted to the registrar for approval within 60 days of the board's resolution approving the amendment. And 3, any amendment to the rules which affects the financial condition of the fund shall be accompanied by a valuator certificate certifying that the amendment will not render the fund financially unsound. Fourthly, once the registrar is satisfied that the amendment is not against the members' or employer's interest and not inconsistent with this Act, he shall register the amendments and return an endorsed copy of the amendment to the fund. The resolution of the board must clearly state the effective date of the amendment. And sixthly, a fund may consolidate its rules at any time, which shall take effect from a date decided by the management board, but usually after 10 amendments have been made to the original rules. Right, protection of retirement fund benefits. The general rule set out in terms of Section 37A of the Pension Fund Act is that no benefit of a member may be reduced, transferred, ceded, or pledged by a fund other than as provided for in the Act. So the pension fund can't just do as they please with your money. For the same reason, a member in debt may also not pledge, transfer, or cede their retirement benefits to satisfy their debt. You can't use your pension fund as surety for debt that you make. Section 37D of the Pension Fund Act does not permit certain deductions from a member's retirement fund benefit. Sorry, it does permit certain deductions. These are amounts due in respect of housing loans. So if you owe a housing loan on the fund, they can deduct it against your fund value, granted by the fund, the employer, or for which the fund or the employer agreed to stand surety. So that's for housing loans. Pension interest awarded to former spouses on divorce. The court will then decide how much the divorced spouse will receive, and that amount the fund can then release. Maintenance claims awarded against a member of the fund, and damages due to an employer caused by a member's misconduct. Misconduct must include an element of dishonesty by the member. Mere negligence by the member will not suffice. It is according to the decision of the High Court in a case, Mr. Moodley versus Scottburgh Mzunto North Local Transitional Council in 2004, SA 524D, which is the case number. Right, if we continue with the protection of retirement fund benefits, proof of the member's liability to the employer must be provided to the fund in either a written acknowledgement of liability by the member as well as the amount due. It can also be in the form of a judgment obtained against the member by the employer. It must be noted that a criminal judgment against the member is not an order for compensation to be paid to the employer by the member. The employer should join the criminal case and apply for a compensation order in terms of Section 300 of the Criminal Procedures Act for its claim to be satisfied by the fund. Right, amounts specifically approved by the registrar will then be allowed. Let's have a look at the different types of pension funds, or retirement funds I would rather call it, because a pension fund, provident fund, preservation fund are forms of retirement funds. Right, let's have a look at the pension fund. Under a pension fund, a maximum of 1/3 of the fund benefit may be taken as a lump sum in cash upon a member's retirement. The balance of 2/3 of the benefit will be paid as a pension for the rest of the pensioner's life, subject to the statutory minimum. Amounts below the set minimum can be taken as a cash lump sum amount. Now, currently, the amount that we look at here is 247,500. If that's the total amount of the money in the fund, then they will grant you the whole amount as a lump sum. Provident funds. Under a provident fund, the full fund credit may be taken as a lump sum at retirement. Members have the option to purchase an annuity from their lump sum if they so wish, but I mean, they obviously can go and spend that whole lump sum on buying themselves the most expensive car and whatever they want to, or go on a holiday and then sit without pension. Then you get a preservation fund. Now, a preservation fund basically is a vehicle into which you can either transfer your pension fund or provident fund, or both of them. A preservation fund is therefore a pension and or a provident fund. You get a preservation pension fund and a preservation provident fund, to which a fund member can have his or her withdrawal benefits transferred after exiting their employment. So when you resign at an employer and the next employer you go and work at do not have a pension fund, then you can take that money from your pension fund, transfer it to a preservation pension fund, take your money from your provident fund and transfer it to a preservation provident fund, where this money is then preserved until the age of 55 and up to whatever age you then choose to retire from that fund. Right, and then a fourth type of fund is your retirement annuity fund, which is a single product. A retirement annuity fund is an arrangement set up by an administrator, mostly life assurance companies, for individual members to save for retirement. The tax law allows for retirement from as early as the age of 55 for this purpose. Retirement annuities are also beneficial in estate planning because they are excluded from your estate for estate duty calculation purposes. Now, the same with pension and provident funds and preservation funds. They do not go into the estate for estate duty purposes. Once you reach retirement age, you can buy a life or a living annuity to provide you with a monthly income in retirement. Furthermore, the value of the life or the living annuity is excluded from estate duty purposes. The only downside of a retirement annuity is that you cannot access your saving in a retirement annuity fund before the age of 55 unless you are officially emigrating, and then you will pay tax on that withdrawal amount. Now, whether this is a downside, I don't really think, because there's certain clients, and I had a client of mine that it was beneficial that he couldn't access his money before the age of 55 because he was an alcoholic, and whatever money he could lay his hands on, he did. And I sold him a retirement annuity, didn't tell him he can't access his money until 55. And then when he was wanting to draw money, he came to realize, but he can't get his hands on it. And he had to wait till 55 until he could draw the money. But that was to his benefit. And then he could only draw a third a lump sum, and the other 2/3 was a pension. So at least he had pocket money every month to buy his liquor with. Right. Let's look at beneficiary funds. Beneficiary fund is designed to accept and administer lump sum death benefits allocated to minor dependents by trustees of deceased funds members as set out in section 37C2A2 of the Act. Now, beneficiary funds are most cost effective, tax efficient. The payment is paid out of a beneficiary fund, whether capital or income is tax-free, are governed by professional trustees and offer institutionalized investment returns. However, lump sum payments to a beneficiary funds are subject to tax under the second schedule of the Income Tax Act of 1962. The calculations of tax, if any, will consider any previous lump sums taken by a deceased member during his lifetime. Beneficiary funds comply with the same regulations and governance standards as any other retirement fund, such as member communication policies, investment policies, code of conduct, and risk policy. Right, upon the death of a member, the board then have 3 duties regarding a beneficiary fund. The first duty is to conduct a thorough investigation to identify the circle of potential beneficiaries, for example, dependents and nominees. The second duty is to decide on an equitable distribution of the benefits. And the third duty would be to effect an appropriate mode of payment of these benefits, whether it's monthly, quarterly, in what format it will be paid. Beneficiary funds play an important social role as a mode of payment for trustees to consider, particularly amongst blue-collar worker families where guardians may not be sufficiently financially knowledgeable to manage minors' funds on their own, and where minor children are not staying with their biological parents and their interests may not be sufficiently protected. and then the trustee would then deal with this and make sure that the money gets to the child. The board must note that the payment of the minor child's benefit to her or his legal guardian should be made in the ordinary course of events unless there are valid reasons for depriving the guardian of the duty to take charge of his or her minor child's financial affairs. That's if they are spending the money on other things except on the child. It might not be beneficial for the child if the guardian receive it. The board must consider the following relevant factors in making its decision. Number A, the amount of the benefit. B, the ability of the guardian to administer the amounts of money received. The qualification or the lack thereof of the guardian to administer the amounts of money. So his financial knowledge, his ability to work with money. The time frame until the minor attains the age of majority, the nature of the relationship between the guardian and the minor child, and then obviously the best interest for the minor child. Right, let's look at the next one, which is the unclaimed benefit fund. These are all types of retirement funds. It means it's a fund that is established for the receipt of unclaimed benefits. Now, what is unclaimed benefits? It is any benefit not paid by a fund to a member, former member, or beneficiary within 24 months on the date on which it, in terms of the rules of the fund, became legally due and payable. Then this money is paid into an unclaimed benefit fund. B, a death benefit payable to a beneficiary under Section 37C, but not paid within 24 months from the date on which the fund became aware of the death of the member, or such longer periods as may reasonably justify the board of the funding in writing. C, concerning a benefit payable as a pension or an annuity, any benefit which has not been paid by a fund to a member, former member, or beneficiary within 24 months of the expiry date of any guaranteed period for pension payments provided in the rules of the fund, or the date on which any pension payment or annuity legally due and payable in terms of the rules of the fund became unpaid. D, a benefit payable to a former member who cannot be traced in accordance with Section 15B(5)(e) and which has become legally due and payable to a former member in terms of a surplus apportionment scheme approved in terms of this Act, not paid to that former member within 24 months of the date on which it became legally due and payable. E, any benefit that remained unclaimed or unpaid to a member, former member, or beneficiary when a fund applies for the cancellation of registration in terms of Section 27, or where the liquidator is satisfied that the benefits remain unclaimed or unpaid, or if any amount that remained unclaimed or unpaid to a non-member spouse within 24 months from the date of the deduction contemplated in Section 37D(4)(a)(2), but does not include a benefit due to being transferred as part of a transfer of business in terms of Section 14, where an annuity is purchased in respect of a pensioner or otherwise in terms of this Act. The Registrar of Pension Funds provides a central databases on the FSCA, Financial Sector Conduct Authority's website, to assist members of the public in ascertaining through the search engine if there are any unclaimed benefits due to them. So if you go on the FSCA website, you can go to the section where they have the unclaimed benefits, type in your ID number, and then you'll be able to see whether there is any unclaimed benefits. What is the difference between a pension and a provident fund? Now, we discussed pension funds and provident funds earlier. The main difference is that if a pension fund member retires, the member can get up to 1/3 of the total benefit as a cash lump sum, only 1/3. And the other 2/3 is paid out in the form of a pension. So the member need to take a monthly annuity or monthly income for the rest of the member's life. However, if the remaining 2/3 is below a certain limit, the full value may be payable as a lump sum. So if it's a very small amount and it's not viable for a fund to administer it, then they'll pay it out to you in cash. A Provident Fund member can get the full benefit paid out to them in a lump sum. So that's the main difference. If we look at the advantages of pension funds against provident funds, pension funds provide a monthly pension, where provident funds provide a lump sum payment. Right, some of the advantages of a pension fund: members are guaranteed income security through a monthly pension. Member benefit from the discipline that comes with a monthly income compared to a lump sum which can be abused. It can be paid for life depending on the options that you choose at your retirement. If we look at the Provident Fund's advantages, members has the cash to use as they see fit. No problems with accessing a monthly pension because they've got cash in the bank. A member has the flexibility to access benefits based on their circumstances because the cash all lies within your bank account. Options to take more cash one month than the other than the prescribed 1/3 maximum for pension funds. A member also has the flexibility to buy a private pension annuity without restrictions. So you can take that money, that cash you have, and buy yourself a private monthly pension. What would be the disadvantages of a pension fund? Some pensions do not keep up with inflation. Members has limited flexibility to tailor benefits to individual circumstances. Challenges of receiving a pension for members who retire to remote areas, to get hold of the monthly payment every month. Provident Fund disadvantages: members need to be disciplined when they receive a cash lump sum. Most members use all the money within 6 months of receiving the lump sum. And then they've got problems because then they don't have any more funds left to live on. Right, retirement fund designs. A retirement or pension or provident fund is a legal entity separate from an employer or a service provider. The fund holds all contributions and investments in the name of the fund. A standalone fund serves just one employer, where an umbrella fund combines many employers under one legal structure, usually designed by the service provider. The last few years have seen a huge shift from standalone funds to umbrella funds. The FSCA's annual report shows the number of active funds is down to 1,647 from 1,758. That's now as of March 2017. And at 31st of March 2018, we see the decline from 1,758 down to 1,647. But the picture is even clearer when we compare the number of funds over the last few years, which has dropped considerably from where it used to be at about 5,000 funds and now down to 1,647. The FSCA and the Ministry of Finance have indicated the intention to push for more consolidation of funds, and this can be achieved by more funds moving into umbrella fund arrangements. Some sponsors have stopped administering standalone funds to focus on umbrella funds. Right, if we look at a standalone fund, the main advantage of a standalone fund is the control by the Board of Trustees, whose sole interest is the benefit of the members. Board members are usually fund members. Control over a fund can provide advantages such as the ability to appoint trustees on the board, selecting of preferred service providers, which is administrators, consultants, auditors, etc., as well as control over the members' investment strategies. It is, however, important that the employer has the necessary resources, skills, dedication, time, and numbers to justify the setup of a standalone fund, because administering it can be costly. More care is therefore given in the appointment of service providers, which gives that necessary oversight in the independence to the administration of the fund, and usually the benefits of better efficiency and cost effectiveness. If we look at umbrella funds, on the other hand, an umbrella fund is a retirement fund in which multiple and unrelated employers find a single legal entity to administer this fund. That usually is insurance companies that forms the person that administer the fund. An umbrella fund is usually established by a service provider, which is the sponsor, who appoints the initial trustees, who are normally employees of the sponsor. The sponsor company is usually the appointed administrator and consultant to the fund. Umbrella funds are generally governed by independent and industry experienced trustees who are well versed with the industry and can negotiate the best possible packages for members. Governance is also expected to be much better because of the level of expertise. The one challenge that umbrella funds face is the inherent conflict of interest for trustees, as they are employees of the sponsor's company and therefore protect the interests of the sponsor. Most service providers then perform all services like insurance of risk benefits, investments, consulting, and actuarial services for a reward. The independence of the independent trustee may also be questionable, as they are appointed by the service provider. Umbrella funds are a perfect solution for smaller employees who lack the size to extract scale benefits for a standalone fund. The umbrella fund often has the power to negotiate competitive administrative, investment, and other fees from their service providers than is with a small standalone fund. I mean, it's obvious. I mean, you've got more money and you can negotiate a better deal. Umbrella funds are therefore expected to significantly reduce the average cost per member per month due to the number of services they aggregate. The reality on the ground is not necessarily so. It is important to therefore interrogate the full package before concluding that umbrella funds are cheaper. The Board of Trustees will have a management committee to look after the interests of members relating to particular participating employers at the employer level, but work with the parameters set by the board. Right, let's have a look at the legal structure of these two funds, the standalone and the umbrella retirement fund. One set of registered rules with a registrar for the standalone fund, where the umbrella fund is registered under the umbrella rules with a registrar. Special rules, participation certificates for each participating employer. We look at the management of the fund. It's managed, the standalone fund is obviously managed by its own management. It's managed by a board of trustees at the employer level. 50% of the board of trustees are elected by the members, and 50% are appointed by the employer. The board of trustees has fiduciary responsibilities, and decisions made are binding to the whole fund. Management of the umbrella fund, it's managed by a board of trustees at the fund level with a management committee at the company level. The sponsors appointed the board of trustees with a management committee appointed by the employer and members. The management committee does not have fiduciary duties, as they operate within the limits set by the board of trustees. Decision making is confined to the participating employer. What's the benefit structures? A standalone fund, the trustees are responsible for designing the fund's benefit structure with no external consideration other than affordability on the employer's part, taking into account the members' needs. On the umbrella side fund, participating employers design their benefits within the umbrella fund parameters, and most umbrella funds offer a degree of flexibility to cater to different employers' broad needs. Right. If we look at the investment side, the board of trustees are responsible for the investment strategy, whereas on the umbrella side fund, the board of trustees set the investment strategy. The management committee will select a default plan for its members within the framework set by the board. If we look at cost structures for the standalone retirement fund, the fund meets cost for fidelity insurance, actuarial services, audits, and rule amendment registration. Costs on the umbrella side fund, costs for things like fidelity insurance, actuarial services, audits, and rule amendment registration, in this case, are shared by all the participants, which then make it a cheaper arrangement. Right, that conclude our session on Introduction to Retirement Funds, which is Unit 2. The next session we will start with will be Unit 3. There we'll look at the legal and regulatory framework of a fund. Thank you for attending this session. See you then in the next session.